Hello once again. Welcome to the Public International Law course. In this program, we will continue our course with International Criminal Law, which is Chapter 7. In this chapter, we will talk about history and sources of international criminal law, international criminal tribunals, the International Criminal Court, jurisdiction of the International Criminal Court, and terrorism as an international crime. We should begin with the history and sources of international criminal law. International criminal law is relatively a new branch of international law. Classical international law did not focus on international crimes because individuals were considered as objects of international law. Individuals were not endowed with any rights or duties with the exception of piracy. During the 19th century and before the First World War, only war crimes were punishable for which the vanquished state, not an individual, was deemed guilty. However, it was only after the First World War that a truly international criminal tribunal was envisaged to try perpetrators of crimes committed during the war. After the Second World War, revolutionary changes came in this area. The Allied powers set up two international military tribunals to try the criminals who committed war crimes, crimes against humanity, crimes against peace, and conspiracy to commit these crimes. The UN General Assembly in 1946 affirmed the principles of the Nuremberg Tribunal and the decision of the tribunal. Following on the judgments of the Nuremberg and Tokyo International Military Tribunals, in 1951, the International Law Commission, or ILC, in pursuance of the General Assembly resolution, formulated a draft code of offenses against the peace and security of mankind. The 1990s witnessed the establishment of international criminal tribunals. In 1993, the UN Security Council established the International Criminal Tribunal for the former Yugoslavia, or ICTY, and the International Criminal Tribunal for Rwanda, or ICTR, in 1994. These are the most important and ad hoc tribunals created to try the perpetrators of crimes, followed by the establishment of the International Criminal Court, or ICC. Let's continue with the International Criminal Tribunals. The end of the Second World War heralded the constitution of international military tribunals to try war-related crimes. With the end of the Cold War in the early 1990s, the world also witnessed the establishment of international criminal tribunals that would deal with crimes resulted mainly from internal armed conflicts. These conflicts, fed on nationalism and fundamentalism, resulted from the disintegration of multi-ethnic societies, which committed serious violations of international humanitarian law and basic human rights. With a serious sense of protecting human dignity and to punish those assaulting such dignity, the international community responded by establishing international institutions with authority to prosecute and punish those persons involved in the violations. Now, it's important that we talk about the International Criminal Court, or ICC, and how it was formed. The attempts to establish an international permanent criminal court started by the Committee of Jurists in 1920. The League of Nations drafted a convention for the creation of an international criminal court in 1937, consisting of 5 judges and 5 deputies to be elected by the Permanent Court of International Justice. The convention failed to come into force due to lack of ratifications. Therefore, the attempt to establish the court also failed. In 1952, a new committee was assigned to the task. However, the Cold War conditions made the establishment of International Criminal Court politically unrealistic. The idea to establish a permanent criminal court revived in 1989. In 1994, the Commission completed a comprehensive draft statute and submitted it to the General Assembly. The draft treaties subsequently led to adoption of the Rome Statute of the International Criminal Court by the Diplomatic Conference of Plenipotentiary held in Rome between 15th of June and 17th of July 1998. The Rome Statute came into force on the 1st of July 2002. Therefore, the ICC can only prosecute crimes committed on or after July 1st, 2002. The court's first judges were elected in February 2003. The ICC issued its first arrest warrants in 2005. The court has so far indicted 39 individuals. Article 36 of the Rome Statute outlines the qualifications and procedure of election of the judges of the court. The ICC consists of 18 judges. The number may be increased on a proposal of the presidency, indicating the reasons for the increase. Judges shall be chosen among persons of high moral character, impartiality, and integrity who possess the qualifications required in their respective states for appointment to the highest judicial offices. Let's move on to the jurisdiction of the ICC. There are 3 jurisdictional requirements under the Rome Statute that must be met before a case may start against an individual. They are subject matter jurisdiction, territorial or personal jurisdiction, and temporal jurisdiction. The ICC has been created with an avid aim that the most serious crimes of concern to the international community as a whole must not go unpunished. Crimes so enlisted are the crime of genocide, crimes against humanity, war crimes, and a crime of aggression. They are defined in the Rome Statute's latter articles from 6 to 8. Apart from these primary crimes, Article 70 defines offenses against the administration of justice when committed intentionally for which an individual can be prosecuted. Our final topic for this program is terrorism as an international crime. International crimes that are breaches of international rules entail personal responsibility of the individuals. These are war crimes, crimes against humanity, genocide, torture, aggression, as well as state-sponsored or state-tolerated terrorism. Illicit traffic in narcotic drugs and psychotropic substance, the unlawful arms trade, smuggling of nuclear and other potentially deadly materials, or money laundering are generally not considered international crimes. The term terror comes from the Latin verb terrere, meaning to frighten. In modern times, terrorism usually refers to the killing of innocent people by a private group, usually to achieve some political goals. An act of terrorism amounting to international crime should have an international element. That is, it should involve 2 or more states. Terrorist activities carried out within a state are criminal offenses punishable under the relevant laws of the state concerned. There is no universally agreed, legally binding criminal law definition of terrorism. Various legal systems and government agencies use different definitions of terrorism in their national legislation. In this regard, terrorism primarily refers to violence against civilians or non-combatants, including public officers, law enforcement agencies, and military personnel. In the absence of an agreed definition, scholars generally hold that it is difficult to criminalize terrorism under international law. One can conclude that terrorism as an international crime has the following elements. The act must constitute a criminal offense under most national legal systems, such as murder, kidnapping, hostage-taking, bombing, torture, etc. The act must be aimed at compelling a state, an international organization, or a non-state entity to do or to abstain from doing any act, either by spreading terror among the population by means of violent action or threat thereof directed against a state official, an intergovernmental organization, a public or private body. The act must be motivated by political, religious, or otherwise ideological reasons and not by private motives. After a heavy topic, we have come to the end of our program for Chapter 7 of the Public International Law course. Goodbye, and don't forget to watch our final program, Chapter 8.